Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. It's a bit of a quiet week, news-wise in immigration, as the holidays often are. Dare I say the calm before the storm? I have a feeling we will come to cherish weeks like this in the coming years. So if I used the calm to highlight some patrons last week, I'll use my bully pulpit this week to mention Immigrants List upcoming December 11th Zoom event, because it seems pretty cool. Join Immigrants List on Wednesday, December 11th, 2024, from 5:30 to 6:15 p.m. Eastern Standard Time for a post-election discussion with the U.S. Senator from Massachusetts, Ed Markey. Throughout his time in Congress, Senator Markey has remained a leader in the fight for pro-immigration reform. He stood up, for example, to the Trump administration last time around, successfully leading efforts to reverse its decision to end consideration of medical deferred action requests for sick immigrants. Senator Markey also introduced critical pro-immigration legislation, such as the GRACE Act, which would prevent any administration from settling the admissions ceiling below 125,000 in a given fiscal year. He is the leader we need, according to Immigrants List, in the Senate to stand up against the attacks against the immigrant community by the incoming administration and the anti-immigrant majority in Congress. So good on Immigrants List for getting him to speak, and thank you to the Senator for donating his time. We'll need more like him in the coming years. Also, in the weird immigration case law podcast news that I so often do, this week, the Sixth Circuit amended its Mazariegos Rodas et al. V. Garland decision from episode 230. But it's not apparent to me what they amended or even where. So just note it when you rely on this helpful asylum decision and make sure that you're reviewing the December 5th, 2024 edition. That's all I got. That and this one decision. Pot on. Are you struggling to find and hire new talent that you can trust? Does the idea of onboarding, training, and managing virtual staff overwhelm you? Staffy's got your back. Staffy provides top-quality virtual staffing for immigration law firms, complete with HR support to free up your time from the hassles of onboarding, managing, and continuously training your virtual staff. With an entire team of professionals, including psychologists and mindset, task, and performance coaches, Staffy ensures your virtual staff has all the tools needed to help your law firm grow and scale. Visit staffy.cc, that's stafi.cc, and schedule a consultation to claim $500 off your first month of service. Or, of course, click on the link in the show notes. You're probably hearing a lot of buzz about how law firms are starting to use artificial intelligence. And well, I recently had the opportunity to talk to the folks at Serenade about their case management system, e-immigration. They've been making software for immigration attorneys longer than anyone else. And they're doing some pretty cool stuff with AI. They have a suite of tools that they're calling AI Workmates. That sounds like it's got huge time-saving potential. One of their tools even lets you upload a PDF and instantly creates a client profile. There's another tool that can read content on the website and instantly summarize it, which is pretty helpful when referencing historical case rulings or, dare I say, country condition evidence. They've got some other tools too scheduled for release later this year. So if you're trying to wrap your head around how to use AI in your practice, I encourage you to have a chat with the folks at Serenade. Also, check out their blog at serenade.com/blog for their recent articles on AI in legal practices. Or, of course, click on the link in the show notes. Our first and only case is Escobar Larin v. Garland, published by the First Circuit on December 5th, 2024. This case is primarily about asylum and related relief, and it arrives to us, as so many in the First Circuit do, thanks to the hard work of ACLU New Hampshire. Mr. Escobar is from El Salvador, entered the United States without authorization as a child, and when placed in removal proceedings many years later, applied for asylum and related relief by himself without an attorney. Pretty wild for anyone to do, but Mr. Escobar was exhibiting mental health issues, and an immigration judge ultimately deemed him incompetent to represent himself pursuant to the BIA's matter of MAM decision, meaning that he got an attorney appointed for him. That attorney, appropriately I imagine, filed an amended asylum application with the IJ. Counsel asserted a variety of mental health, gang-related, and even family-based reasons for Mr. Escobar's fears of return, as well as imputed political opinions. A legal brief was submitted. That brief, pertinently, acknowledged that Mr. Escobar had not filed for asylum within 1 year of entering the United States as asylum requires, but that he should be excused due to extraordinary circumstances that stood in his way and materially changed circumstances, as the statute and regulations permit. The extraordinary circumstances alleged were mainly his mental health issues. And in fact, 8 CFR section 1208.4A5 expressly provides that, quote, extraordinary circumstances may include an applicant's serious illness or mental disability during the 1-year period after arrival, or a legal disability during the 1-year period after arrival, such as the applicant's mental impairment or status as an unaccompanied minor, end quote. Mr. Escobar argued that his status as a minor when he entered the U.S. in 2004, combined with his later mental health issues, should accept the 1-year filing deadline, albeit for like 17 years. No small ask, but the facts might be here, particularly with the mental health stuff, which included schizophrenia. Plus, those regressing mental health developments led to new fears, another statutory and regulatory basis for extending the 1-year deadline to file due to, again, materially changed country conditions. Supporting evidence was submitted, including United Nations and other country condition evidence, and of course, psychological records and analyses. The IJ, however, was not swayed, and refused to extend the 1-year deadline and find the asylum application timely. The IJ alternatively denied asylum on the merits. The IJ also denied withholding of removal and protection under the Convention Against Torture, neither of which have a 1-year filing deadline, but both are difficult to obtain. The BIA initially affirmed and remanded in part. As written here, it seems like a bit of a strange remand, and on remand the IJ ruled similarly, I guess with just more detail and analysis. This time the BIA affirmed it full. While a First Circuit petition for review was pending, Mr. Escobar filed a motion to reopen with the BIA, submitting additional evidence that he believed might have changed the result below, had it been known and available before. It was primarily based on a new declaration on country conditions in El Salvador from a Dr. Manisha Gelman, and then another declaration from a Dr. Samuel V. Nichols. The BIA eventually denied the motion to reopen. The First Circuit affirmed denial of the motion, but remanded for further asylum analysis, which, if I'm being honest, very well might get some of that new expert evidence in anyway. So there you go. I'll address the motion to reopen first, as did the First Circuit. To result in reopening, among other things, the new evidence that the motion is based on must actually be new and previously unavailable. It also, of course, must be material. Recent case law discussed on the pod from other circuits has highlighted that this doesn't mean, though, that the new evidence did or did not exist in the world, but rather that the new evidence was not reasonably available or accessible to the non-citizen before. A pretty important distinction, right? Especially when dealing with non-citizens with mental health issues. But it seems that Mr. Escobar didn't make that argument to the BIA. Not only might that mean that the argument isn't exhausted, but the First Circuit held here that meant that the evidence wasn't present in the record to show that this was in fact the case. That is, that the evidence wasn't previously available to Mr. Escobar because of his mental health issues. Nor in any event did the First Circuit see the expert declarations as so clearly showing a change in circumstances that reversal of the BIA was required. So the First Circuit didn't. But again, asylum in chief, the IJ's original denial and then the denial on remand that was then affirmed by the BIA. The First Circuit isn't so sure about that and sent it back. Lots of holdings though. First, whether the asylum application, admittingly, filed like 17 years untimely, should be deemed timely. The First Circuit actually affirmed the agency on this. Seems like it saw the record a bit deficient on the issue, that is, the fact that Mr. Escobar could not have filed this asylum application in the preceding 17 years, particularly given the fact that Mr. Escobar did have the ability to work, he married, and he had a child during the 14 years after he became an adult in the United States. Seems like his mental health issues may have progressively gotten worse over the years, but that kind of undermines an argument that the 1-year deadline should be extended for so many years, reasoned the agency and the First Circuit, essentially. But whether there exists changed circumstances such that Mr. Escobar should get another shot at pursuing asylum, that's another analysis entirely. And here is where he got his remand. Not for nothing, the First Circuit first held that it was a reviewable question of law. At least here, where the non-citizen argued that the IJ and the BIA, quote, applied the wrong changed circumstance standard in deciding that no changed circumstance exception could have applied to the asylum application solely because he would have already been eligible for asylum at the time of his entry to the United States in 2004, end quote. That's one way to turn an issue into a reviewable legal one. That's not the case, explained the First Circuit. In every circuit as well to review the issue so far, which includes the 6th, 4th, 2nd, and 9th circuits according to the panel. The standard to make an untimely asylum application timely based on changed circumstances is that the changed circumstances materially affect an applicant's asylum eligibility. It doesn't have to be an entirely new claim. It could have been partially present at the get-go. Heck, the First Circuit reads the BIA as having said as much in matter of DGC from 2021, episode 59. You know, I've found episode 59 to be an important one over the years. Go back and check it out. Anyways, the First Circuit doesn't think the BIA properly analyzed the issue and seems to have doubts about the IJ's analysis too, particularly on whether Mr. Escobar's schizophrenia was a changed circumstance that should give him another shot. After all, his attorney amended the asylum application in August 2022 to assert a fear based on the group, quote, Salvadorans with unspecified schizophrenia spectrum and other psychotic disorders who exhibit erratic behavior, end quote. And he was only first clearly diagnosed with the illness in January of 2022. So again, the First Circuit sees problems with the agency's changed circumstances analysis that the agency used to preclude review of the asylum application. But it shouldn't really matter, right? Because the IJ and the BIA also alternatively denied the asylum application on the merits, assuming it timely? Well, the First Circuit saw error there too. To Mr. Escobar, the IJ did not sufficiently consider the effect his mental health issues would have on his fear of gangs in El Salvador. Oil put up a fight, but also admitted that the IJ's findings on the issue were, quote, not of ideal clarity, end quote. Not good enough, said the First Circuit. To the court, the IJ didn't consider gangs at all when analyzing the mental health-based fears. And that was remandable error. Probably going to get those new expert reports in then, right? If the First Circuit's footnote on the issue is any indication. Withholding of removal then? Same problem. But on Convention Against Torture Protection, not so much. It's a long decision, and who wants CAT anyway when you might get asylum? To cut to the chase, the First Circuit read the record differently from Mr. Escobar and believed that the IJ properly required a showing that the Salvadoran government would acquiesce to torture by non-state actors like gangs, but didn't require such a showing for the claims premised on torture from the Salvadoran government itself, appropriately. But yet still a remand on CAT. Because to the First Circuit, the IJ and the BIA appear not to have properly aggregated the risk of all asserted sources of torture together. If the First Circuit actually made that holding, that is, the aggregation requirement, this would be a holding of law that would be a bit of a first for the First, explains the First. But as the First Circuit so often does, the court did not actually make the ruling, and instead remanded to the BIA to decide whether aggregation is the standard of whether it applies or applied in this case, while acknowledging that the requirement to aggregate all sources of torture in CAT claims is the law in all of the other circuits. Pretty dang sure that the BIA has said it too at this point multiple times. Search the pod page, I say. Anyway, with all those remands on complicated issues, that means you know it. Congratulations, Sang-Up Kim and Giles Bissonnette from the ACLU, New Hampshire, on the win. And that is Escobar Larin v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.